So we will start the session. Today we are organizing a webinar session on the Enforcement Directorate under the PMLA powers, constitutional validity, and the emerging jurisprudence. And I request if there is any mic. Okay. So today we have a very special guest with us, Miss Sanskriti Rana. She's an assistant professor of law at Aryan College of Law. She is currently pursuing her PhD in law from Punjab University, Chandigarh, and she also holds LLM in criminal law from HPNLU Shimla. She has participated in various conference papers on the uh, topic of today's webinar at national and international level. So I request Sanskriti, ma'am, please take the stage and start with the webinar session.
Thank you, Varun sir. Good morning, everyone. Let me begin not with a section, not with a statute, not with a citation, but with the question. Imagine that one morning there is a knock on your door. Not a policeman in khaki, no first information report, no magistrate's warrant in hand. Instead, an officer walks in, sits across from you, and begins to ask questions. You are told you must answer, and every word you speak may be used against you. You are not told in writing why are you being investigated. And if you are arrested, the door of bail does not swing open the way it does in an ordinary criminal case. It is bolted shut by two conditions that the law itself calls, and I quote, twin condition. Now ask yourself, is this a police state? Or is this a rule of law doing exactly what a democracy asked it to do? That tension, that uncomfortable electric tension between the power of the state to chase dirty money and the liberty of the individual to be left alone is the entire subject of my talk today. Ladies and gentlemen, distinguished faculty, my fellow members of the bar, LLM and PhD scholars, judicial aspirants, and most importantly, the law students in this room who will inherit this debate, welcome. The institution at the center of this storm has two letters, ED, the Enforcement Directorate. Few agencies in the history of independent India have inspired such fascination, such fear, and such ferocious legal argument in so short a time. Here is something to keep in mind for the next 45 minutes. The Prevention of Money Laundering Act came into force from the 1st of July 2005. For nearly its first decade, it was a sleeping statute. The Directorate registered a few hundred cases a year. And then, somewhere in the last 10 years, it woke up. The arrest, the attachments, running into tens of thousands of crores, the searches, the summons to chief ministers and corporate titans, the ED became arguably the most talked about law enforcement agency in the country. And that awakening forced a single fundamental question onto the desk of the Supreme Court. Is this law and is this agency constitutional? The question was answered, at least for now, in a single monumental judgment in July 2022, Vijay Madan Lal Chaudhary versus Union of India, 545 pages, 241 petitions, and a verdict that upheld almost the entire architecture of the PMLA. But a constitutional question is never truly closed because that very judgment today is under review. Because new benches are gently rereading its line because the jurisprudence is emerging as we sit here. So, my promise to you is this, that by the end of this session, you will understand four things. First, where this law came from and why it is unlike any other criminal law you have studied. Second, what extraordinary powers the ED actually wields, and where those powers came from in the text of the Act. Third, how the Constitution was invoked to challenge those powers and how the court responded. And fourth, where the law is heading now in the most recent decisions of 2023 and 2024. Let us begin where every good legal story begins, not with the answer, but with the problem. Let me tell you what money laundering actually is. Because if you do not understand the disease, you cannot cure the, sorry, you cannot judge the cure. Picture a criminal who has just made a fortune from crime, drugs, corruption, fraud, terror financing. He has a problem the rest of us would envy and dread in equal measure. He has too much dirty money and no way to spend it openly. Money laundering is the process of solving that problem. Lawyers and economists described it in three classic stages. First, placement. The dirty cash enters the financial system. Second, layering. It is moved through dizzying maze of transactions, shell companies, fake invoices, cross border transfers. And the third, integration. The money re emerges, washed and gleaming as a legitimate asset, a flat, a company, or a luxury car. The genius of the criminal is that by the third stage, the money looks clean. The genius required of the law is to follow the money backwards, to trace integration, to layering, to placement, and placement back to the original crime. Now, why did India need a special law for this? We already had the IPC, we had the Prevention of Corruption Act, the NDPS Act. Why a new statute? The answer is that money laundering is not an Indian problem. It is a global one, and the response was global. In 1988, the Vienna Convention, the Convention against the illicit trafficking in narcotic drug, first called a nation to criminalize the laundering of drug proceeds. In 1989, two things happened in the same year. The Basel Statement of Principles told banks how to behave, and at the G7 summit in Paris, the Financial Action Task Force, the FATF, was born with its famous 40 recommendations. Then in 2000, the Palermo Convention against the transnational organized crime widened the net from drugs to the widest range of predicate offenses. India was a signatory to these commitments, and so the Prevention of Money Laundering Bill was introduced in 1998, and it was referred to the Standing Committee, debated, and finally enacted as the PMLA 2002, which was brought into force on 1st July 2005. Now, here is the first crucial idea I want you to carry home. The PMLA is not an ordinary penal statute. The Solicitor General himself described it in an argument as an amorphous or hybrid statute. It has three personalities living inside one act. First, it is preventive. It stops the enjoyment of crime proceeds. Second, it is regulatory. It imposes reporting duties on banks and intermediaries. And third, it is penal. It punishes. So, this threefold character is not academic trivia. It became the central plank of the government's successful defense of the Act before the Supreme Court. Because if the PMLA is more than a mere criminal law, then it perhaps need not behave like one. And watch how the very definition of the offense evolved, pushed forward again and again by the FATF's evaluations of India. In 2002, Section 3 said you commit the offense if you deal with proceeds of crime and project it as untainted property. The FATF said that is too narrow. Mere concealment, possession, and mere use of dirty money should be enough. So, in 2012, the Parliament amended Section 3 to include concealment, possession, acquisition, and use. And in 2019, an explanation was inserted to clarify that money laundering is a continuing activity. It does not end the moment the money is laundered. It continues as long as you enjoy the proceeds of the crime. Remember that phrase, continuing offense? It will return when we'll discuss arrest and bail, and you will see why every word in this statute is a load bearing wall. Now, let us walk into the engine room of the statute. Let us see the powers. I want you to notice something as we go. Every power we discuss has an ordinary criminal law cousin, and every power departs from that cousin in some striking way. That departure is the source of both the act's effectiveness and its controversy. So, starting with the heartbeat of the whole act, the expression in section 2, subsection 1, clause U, proceeds of crime. The Supreme Court called this the fulcrum, the pivot of the entire law. Proceeds of crime means any property derived directly or indirectly from a scheduled offense, or the value of such property, or where the property is taken abroad, property of equivalent value held in India. Now, here is the chain you must never forget. There is no money laundering without the proceeds of crime, and there are no proceeds of crime without a scheduled offense, that is a predicate offense. Pull out the predicate offense and the whole PMLA edifice in that case collapses. Now meet the most fascinating creature in this entire law, that is the ECIR, the Enforcement Case Information Report. When the police investigate, they register an FIR under section 154 of the Criminal Procedure Code. The accused is entitled to a copy. It is a public document. It is a foundation of his right to defend himself. The ECIR is not an FIR. The Supreme Court held in Vijay Madan Lal that ECIR is an internal document of the Directorate. The accused is not entitled to it as a matter of right. It is enough, the court said, at the time of arrest, the person is informed of the grounds of arrest. A person may be investigated, summoned, even under the law as it then stood, arrested, without ever being handed the document that started it all. The court's justification? The court said the PMLA is sui generis, one of a kind, and the ECIR has no statutory equivalent to the FIR. Next, section 50, the power to summon, to compel attendance, to record statements on oath. And here is the constitutional thunderclap. When an ED officer records your statement under section 50, you're bound to speak the truth. Refusal or falsehood is itself an offense. The students will immediately ask, ma'am, what about Article 20, Clause 3, the right against self incrimination? No person accused of an offense shall be compelled to be a witness against himself. The court's answer was surgical. It held that ED officers are not police officers, and the statement under Section 50 is not a confession to a police officer, barred by the Evidence Act. Crucially, the court said at the stage of summons, the person is not yet formally accused. So, Article 20, Clause 3 is not attracted at that point. The protection, the court reasons, kicks in later. You may agree or disagree, and many.
Sorry for interruption, ma'am. Ma'am, we are not able to see the slides. Only the title slide is there. So are we only on the title side, or are we moving up and down somewhere? Because it will help us to prepare the notes as well along with the discussion.
Okay, I'll see to it. Wait a minute. Is the screen visible now?
Yes, it is.
Okay. Now the money powers, these are extraordinary. Under Section 5, the ED can provisionally attach property it believes to be proceeds of crime before any conviction, before any trial. The attachment lasts 180 days and subject to the confirmation by the adjudicating authority under Section 8. Under Section 17, the ED may search and seize. The earlier requirement of a connection to a registered scheduled offense was diluted by amendment. Ordinary criminal law says first convict and then confiscate. The PMLA says attach now, adjudicate the property stained in parallel. This is the preventive personality of the act in full force. The idea being that if you wait for the conviction, the money vanishes across borders. And indeed, the data bears this out. Assert worth thousands of crores connected to a high profile fugitive cases were attached and substantial portions returned to the public sector banks precisely because the law allowed early attachment. Then, Section 19, the power to arrest. An authorized officer may arrest a person. An authorized officer may arrest in person if, on the basis of material in possession, he has reason to believe, recorded in writing, that the person is guilty. The grounds must be communicated, the arrested person produced before the special court within 24 hours. The court in Vijay Madan Lal upheld Section 19, finding the safeguards, recorded reasons, communication of grounds, judicial production sufficient. But notice the standard, reason to believe, not reasonable suspicion. A higher threshold on paper. Whether it is a higher threshold in practice is precisely what later judgments would scrutinize. And we will come to Pankaj Bansal and Arvind Kejriwal shortly. Now, one of the most constitutionally daring provisions in the entire statute, Section 24, the reverse burden of proof. In ordinary criminal law, the golden thread, as Viscount Sankey called it, is that prosecution must prove guilt beyond reasonable doubt. The accused is presumed innocent. Section 24 turns this around. Once certain foundational facts are established by the prosecution, the law presumes that proceeds of crime are involved in money laundering and the burden shifts to the accused to prove otherwise. But, and the court was careful here, the presumption is not automatic. The prosecution must first establish that the court in Prem Prakash, which was held in 2024, restated as three foundational facts. One, that a schedule offense was committed. Two, that the property was derived from that criminal activity. Third, that the accused was connected to the process or activity involving that property. Only then does the burden shift. The presumption is rebuttable and not conclusive. And now we arrive at a provision that has launched 1,000 bail applications, Section 45, the twin conditions for bail. Under Section 45, no person accused under the PMLA shall be released on bail unless the public prosecutor is given an opportunity to oppose. And second, the court is satisfied that there are reasonable grounds for believing that the accused is not guilty of the offense and that he is not likely to commit an offense while on bail. The judge must form a prima facie opinion of innocence before granting bail at a stage where when the trial has not even begun. So this is the inversion of the ordinary rule, which says bail is the rule and jail is the exception. Under section 45, jail looks like the rule. Now here lies one of the most dramatic episode in the story. In 2017, in Nikesh Tarashan Shah case, the Supreme Court struck down the twin conditions as unconstitutional, violative of Article 14 and 21. The provision lay dead. Parliament then revived it by an amendment in 2018. And in 2022, Vijay Madan Lal upheld the revived twin conditions as constitutionally valid. A provision struck down, resurrected by Parliament, and re-blessed by the court. So now we have the full arsenal in view. The natural question, the constitutional question is this: can a single statute do all of this and still survive the Constitution of India? The question came to a head in Vijay Madan Lal versus Union of India, decided on July 2022 by a three-judge bench led by Justice A.M. Khanwilkar. It was a colossus. Over 240 petitions clubbed together, attacking nearly every operative provision of the Act. The petitioner argued that PMLA had become a draconian instrument that ran roughshod over Article 14, 20, and 21. Now, let me take you briefly through what the court actually held and then through what the critic says. One of the definition of money laundering under Section 3, the court upheld the wide definition, agreeing that even concealment, possession, acquisition, and use of proceeds of crime standing alone can amount to the offense. The word "and" before projecting as untainted was read disjunctively. Money laundering, the court affirmed, is a continuing offense. Second, Section 5 attachment was upheld as reasonable provision balanced by adjudication. Third, Section 19, the power to arrest was upheld and its safeguards held to be adequate. Fourth, the ECIR need not to be supplied to the accused. It is not equivalent to FIR. Fifth, Section 50 statements do not violate Article 20, Clause 3. The court said ED officers are not police officers. Sixth, Section 24 reverse burden was upheld as having reasonable nexus to the object of the Act. Seventh, and most controversially, Section 45's twin conditions were upheld as constitutionally valid. The court holds that they do not impose an absolute restraint on bail, but place a structured judicial discretion in the court's hand. Now, what was the thread running through all of it? The court repeatedly emphasized that money laundering is not an ordinary crime. It is an offense against the nation, against its economy and its sovereignty. It is, the court said, often more serious than a conventional crime because it strikes at the financial integrity of the country and is frequently linked to terror financing. The reasoning, in essence, extraordinary threats justify extraordinary measures provided procedural safeguards exist. The PMLA, the court found, was a law born of India's international obligations under FATF, Vienna, and Palermo, and a constitutional court should be slow to dismantle a framework that aligns the nation with the global fight against dirty money. But a good professor always gives you the other side. And Vijay Madan Lal is one of the most criticized judgments of the modern Supreme Court. Let me give you the principal criticism fairly stated. First, on the ECIR, critics argue that denying the accused of the foundational document undermines the right to a fair defense and principle of audi ultram partem. How do you defend yourself against a case you have not been shown? Second, on section 50, scholars contend that the distinction between a noticee and an accused is artificial. That a person whose statement can later anchor his own prosecution is in substance being compelled to incriminate himself. And on third, section 45, the criticism is that asking a judge to be satisfied of innocence before trial effectively inverts the presumption of innocence, the very foundation of criminal justice. Fourth, a procedural critique that a statute of this magnitude was substantially amended through the money bill route, a question of the court expressly left open for the larger bench. And here is the most important sentence I will say in this section. In August 2022, just weeks after the judgment, the Supreme Court, in a review petition, Karti Chidambaram's matter, observed that at least two aspects of Vijay Madan Lal require reconsideration. First being the non-supply of the ECIR, and second, the reverse burden of proof under section 24. The court found these prima facie deserving of review. So the constitutional question is not closed. It is pending before a larger bench. Now, even while the constitutional architecture stands upheld, watch what the court has been doing quietly but powerfully in the cases that followed. It has been re-centering Article 21, the right to life and personal liberty, as the higher constitutional law to which even the PMLA must bend. In Prem Prakash 2024, the court said, it plainly, Article 21 being a higher constitutional right, statutory provisions should align themselves to the said higher constitutional edict. Section 45, the court held, does not rewrite the principle that liberty is the rule and deprivation the exception. It merely adds conditions that must be satisfied, yes, but conditions that cannot be allowed to become a sentence served before the trial. So where does this constitutional balance settle? Like this, the structure of PMLA stands, but its operation is being increasingly disciplined by the courts. The statute survived the constitutional challenge, but the liberty jurisprudence is staging a quiet, determined comeback. And that brings to us the most dynamic part of our story, the emerging jurisprudence. In Vijay Madan Lal in 2022, represented the higher watermark of the agency's power. Then 2023 and 2024 represents the pendulum swinging back towards the liberty. Let me give you the landmark cases, and I want you to see them not as an isolated decisions, but as coherent course correction. First is Pankaj Bansal versus Union of India, 2023. The question is, in what form must the grounds of arrest under section 19 be communicated? Orally or in writing? The court held that the grounds of arrest must be furnished to the arrested person in writing. Merely reading them out is not enough. So, this was a direct strengthening of the safeguard the court had said in Vijay Madan Lal already existed. Pankaj Bansal gave the safeguard teeth. An arrest that fails to supply written grounds is illegal, and the arrest and consequent custody can be quashed. In Tarseem Lal versus Directorate of Enforcement 2024, a quieter case but a profoundly important one for personal liberty, and one I want you to know well. The facts: the accused person who were never arrested during the investigation, the complaint is filed, the special court takes cognizance, they appear in response to the summons. Now, can the ED arrest them under Section 19? The Supreme Court, through Justice Abhay Oka, said no. Once the special court has taken cognizance of the complaint, the ED is powerless to invoke Section 19 to arrest an accused named in the complaint who was not arrested during the investigation. And listen to this: when such an accused appears on summons, he is not deemed to be in custody and therefore need not even apply for bail or satisfy the twin conditions of Section 45. The court can simply take a bond under Section 88 of the CRPC. Now, why does it matter? Because the court expressly held the opposite practice, arresting an accused the moment he appears, forcing him to seek bail, would offend the right to liberty guaranteed by Article 21. There it is again, Article 21, the higher law, doing its quiet work. The Manish Sisodia case and the line that flows from them. In Manish Sisodia 2024, the court delivered a sentence that has since echoed through every trial in the country. Let me read it because the language matters. It is high time that the trial courts and high courts should recognize the principle that bail is the rule and jail is the exception. The court reasoned that prolonged incarceration before being pronounced guilty cannot be permitted to become the punishment without trial. And it held that where an accused has been in custody for a long time with no realistic prospect of the trial concluding soon, the rigors of Section 45 can be suitably relaxed to grant conditional liberty because Article 21 is the higher constitutional mandate. So, this is the doctrine of bail on the ground of delay. And it perhaps the single most significant liberty protective development in PMLA jurisprudence today. In Prem Prakash versus Union of India 2024, two contributions. First, the court crisply restated that the three foundational facts the prosecution must establish before the Section 24 presumption can shift the burden, reminding everyone that the burden does not shift automatically. Second, and very practically, the court placed a duty on the prosecution's counter affidavit and at the bail stage, and it must specify or crystallize how those foundational facts are prima facie made out. In other words, ED cannot simply assert guilt and rely on the 10 conditions to keep a person in jail. It must show its work. In Arvind Kejriwal versus Directorate of Enforcement 2024, here the court drew a sharp distinction that every advocate must master: the difference between the power to arrest and the need to arrest. Even where the power under Section 19 exists, the officer must apply his mind to whether the arrest is necessary. The threshold of reason to believe must rest on material, and that the belief is subject to judicial review. The court reinforced that Section 19 is not a license for arrest at will. And finally, a thread that ties back to where we begin. The court have firmly reaffirmed if a schedule offense, the predicate offense collapses, if the accused is discharged or acquitted of it, or the proceeding is quashed, then there can be no offense of money laundering. No predicate, no proceeds of crime, no proceeds of crime, no laundering. Vijay Madan Lal itself reaffirmed this. It is the structural remit, but into the very heart of the act, it is a vital safeguard. Now, do you see the pattern? Pankaj Bansal, Tarseem Lal, Manish Sisodia, Arvind Kejriwal, different facts, one direction. The court is saying to the Directorate, your powers are real, your purpose is legitimate, but you will exercise them with the discipline of Article 21. Now, let us step back from the cases and offer you three reflections to carry into your own research and practice. The first tension is effectiveness versus liberty. A toothless anti money laundering law is worthless. Fugitive economic offenders have shown us how easily wealth flees across borders. But a law with only teeth and no restraint is dangerous to a free society. The genius of the constitutional governance is to hold both the truths at once. The PMLA is the laboratory in which India is testing whether it can. The second tension is the agency's dual role. The ED is at once an investigator, an attaching authority, and a prosecutor. Concentration of functions invite the questions every law student should ask: who guard the guardians? The answer increasingly is judicial review, which is grounded under Article 21. The third tension is conviction versus process. Here is a sobering static to provoke your thinking. Despite thousands of cases registered, actual convictions under the PMLA remains remarkably few. Now, this raises a hard question. Is the true impact of this law in its conviction or in its process? Process, which is attachment, arrest, pre-trial incarceration. When the process itself becomes the punishment, the constitutional alarm bells must ring. This is precisely what the Manish Sisodia line of cases is responding to. So, what lies ahead? Three things to watch: the pending review of Vijay Madan Lal, particularly on the ECIR and Section 24, the open question of money bill route of amendment, awaiting a larger bench, and the steady case by case maturing of the liberty jurisprudence under Article 21. The law is not settled, it is settling. And for that, those of us who love the law is the most thrilling state of all. Now, let me return to knock on the door with which I begin. Is it a police state, or is this the rule of law doing its job? The honest answer is it depends on us. It depends on whether the officer who knocks act on material and not on whim. It depends on whether the judge who hears the bail plea remembers that liberty is the rule. It depends on whether you, the advocates, the scholars, the judges of tomorrow, keep both eyes open. One on the menace of dirty money, and one on the citizen whose freedom is the reason this republic exists today. The Enforcement Directorate is neither hero nor a villain. It is an instrument, and like every instrument of state power, it is as just or as dangerous as the constitutional discipline we impose on it. The PMLA was upheld in Vijay Madan Lal, but the real judgment on this law is being written every single day. In every trial court that grants bail to a person held too long without a trial, in every high court that quashes an arrest made without written grounds, in every advocate who insists that the reason to believe must mean exactly that. I want to leave the students in this room with a single charge. Do not learn this subject merely to pass an examination or argue a brief. Learn it because you are the next generation of guardians of the balance between a state strong enough to chase crime and the constitution strong enough to chase the state when it overreaches. The framers of our constitution gave us Article 21 not as a technicality, but as a promise that no person's liberty shall be taken except by a procedure that is fair and just and reasonable. The story of the PMLA is ultimately the story of how faithfully we keep that promise, even and especially when we are chasing the guilty. So, with this, I would like to say money can be laundered, justice must never be. Thank you.
Now I request from the participants that if you have any question, please ready with your questions and ask directly from the speaker by unmuting yourselves. And you can also type your questions in the chat box.
Uh, Thank you for the opportunity. I have one query, just seeking a clarification. So in practice, normally we had seen this tendency that there are a bunch of FIRs has been filed against accused, and if one particular accused or the series of accused are getting bail from one FIR, automatically a subsequent FIRs has been filed. So this is my practical experience which I had seen up. So, ma'am, do you feel the same thing, or it's like, have you encountered similar situation where the tendency shows that the prosecution want to keep the accused within the custody irrespective of the fate of the trial or anything? So have you seen similar patterns?
Sir, I'm not in practice, so I'm not aware of it.
Okay, ma'am, thank you.
I think there is no more question. If we can end the session now. Thank you, ma'am. Thank you for the wonderful session. And e-certificate of participation will be awarded to all the participants within 24 hours. If you have any doubts, you can drop your message in the WhatsApp group, or you can send me message on WhatsApp. And I will also share our feedback form with you guys. Thank you to all the participants for joining today's session. Thank you very much.
Thank you, sir, for inviting me.
Welcome, ma'am.
Thank you.